I think we're going to begin. It seems that most people are migrated to their seats. So first of all, I'd like to say I know we're a few minutes behind, and the next presentation is very important and it needs its full hour. So we're going to shorten our presentation a little bit, and we will end promptly at 11:15 so that the next panel could come on, and then we can get you to lunch in a timely manner, because we really know that's why you're here. So I'd like to introduce my colleague, Katie Kenny. Katie had an interesting career path with OCR. She joined OCR as an intern in a summer internship while she was a student at the Washington St. Louis University of Law. I'm proud that Katie has been with us since August of 2010. She focuses primarily and has become our subject matter expert on the breach notification rule. She also works on OCR's audit team, has assisted in the development and the production of the omnibus rulemaking, and takes on an important role in our ongoing guidance initiatives. Katie is a proud graduate of the University of Notre Dame. It can be difficult sometimes in our office of Big Ten graduates. And as I said, she got her law degree at Washington St. Louis University School of Law, where she had a specialization in healthcare. So I welcome Katie.
Thanks, David. So today, David and I will be providing an overview of some of the modifications that were made to the breach notification rule and also the omnibus changes that were made to the business associate provisions of the rule. So this first slide is just intended to provide you with an overview of some of the major provisions that were changed by HITECH, the business associate provision, which David will go into detail on, the marketing and fundraising provisions, the sale of PHI, the right to request restrictions, which was once a permissive right that covered entities had and is now mandatory under the rule, and also individuals now have rights to gain electronic access to their PHI. In addition, the interim final rules for breach notification, enforcement, and GINA have been finalized in the omnibus rule. And these are just some important dates to keep in mind as you adjust to the final rule. It was published in the Register on January 25th of 2013. The effective date was March 26th of 2013. And covered entities and business associates need to be in compliance by September 23rd of 2013. In addition, there is a transition period to conform BA contracts for qualifying contracts, and that is September 22nd of 2014, and David will go into a bit more detail on that. So the interim final rule for breach notification was published in August of 2009 and has been finalized in the omnibus without major changes, but with one significant exception. The definition of breach was clarified through the removal of the harm threshold. The new definition of breach is intended to provide covered entities and business associates with a more objective test for determining when a breach has occurred. The clarification was undertaken in two steps. First, language was added to the definition to clarify that the impermissible use or disclosure of PHI is presumed to be a breach unless the covered entity or business associate can demonstrate that there is a low probability that the data, the PHI, has been compromised based on a risk assessment. And the risk assessment must include at least these four factors. Now, it's important to keep in mind that these four factors are not entirely new. They're new to the regulatory text, but they were included in the preamble to the interim final rule. So a lot of covered entities and business associates might already be using these factors when they're conducting the risk assessments. So the first factor to look to is the nature and the extent of the PHI involved. including the types of identifiers and the likelihood that those identifiers can be re-identified. So some questions covered entities and business associates will want to ask themselves is, how much information was there? Was it clinical information, financial information, and demographic information, or was it just one of those components? And then you will also want to dig a little deeper and look at the specific type of information. Was it the last 4 digits of a credit card number, the last 4 digits of a social security number, or was it the full number, the full credit card information? Those are the types of things that you will want to analyze under this component. The second factor is the unauthorized person who used the protected health information or to whom the disclosure was made. And a question a covered entity or business associate might want to ask themselves with regard to this factor is, did the receiving entity have privacy protection rights of their own? So for example, in the preamble, there's an example that's fleshed out a little bit with this factor when they say a provider faxed PHI to the wrong provider. So that other provider did have privacy protections, has HIPAA obligations to comply with, so that's something you want to take into consideration versus a fax that went to an individual with no rights or restrictions to follow privacy protections. The third factor is whether the protected health information was actually viewed or acquired. And another example that was given in the preamble is, so if a covered entity mailed the wrong information to an individual but then receives that envelope back, returned to sender, then the likelihood that the information was actually acquired or viewed is very low, versus a covered entity that's involved in a mismailing and then an individual calls the covered entity to say, I received someone else's information. Those are examples of 2 very different situations, and you would want to analyze that. The fourth factor is the extent to which risk to the data has been mitigated. So what steps have been taken in the aftermath of the breach? If the breach involved a mobile phone and the data, and you were able to wipe the phone after you were made aware of the breach, then that's something that could be taken into consideration. In addition, if the laptop was recovered after it was stolen and forensic evidence shows that it was not accessed, that's something that you would take into consideration in this factor. And just as a reminder, all 4 factors need to be analyzed in the risk assessment. Covered entities and business associates can't just look to 1 or 2 factors. It is all 4. So the final breach notification rule also eliminates the existing regulatory exception for limited data sets that do not contain any dates of births or zip codes. So while this is no longer an explicit exception under the rule, this should still be taken into consideration in the first factor that we just went over. So you would look to this when you're doing your risk assessment, when you're looking at the nature and the extent of the PHI. So it may be that a breach involving a limited data set with no zip codes and no birth dates ends up having a low probability of compromise, but you do have to look at the other 3 factors as well. It's no longer an explicit exception. Inadvertent or harmless errors that result in an unauthorized disclosure remain exceptions for which no notification is necessary under the breach rule. Additionally, please keep in mind that the safe harbor provision to the breach notification rule was not modified. So if a covered entity or business associate encrypts in accordance with the guidance that was issued to the NIST standard, then breach notification is not required. The final rule retains the interim final rule's requirements for breach notification without modification, but does provide some additional clarification on some of the finer points of when a breach is discovered, methods of notification, and other subtopics. Important clarifications include the final rule preamble noted that if a covered entity is acting as a business associate, for example, if a covered entity is providing billing services to another covered entity in a business associate capacity, then they should respond to the breach as a business associate. In these situations, the obligation to disclose will rest with the covered entity whose PHI has been compromised. The final rule also clarified several points regarding alternative notice and made it explicit that notice has not been given if the written notice is returned as undeliverable. So if covered entities have sent out written notice to individuals, if they've sent that out to more than 10 individuals and they receive these back as undelivered, they can take time to cure this. They can try to find the current address and update the contact information. But if they are unable to do so, they do need to provide substitute notice without unreasonable delay, and in all cases no later than the 60-day, it has to be within the original 60-day time frame as required by the rule. And with that, I will turn it to David for a discussion of business associates.
Thank you, Katie. And again, this is a very brief overview of only two portions of the omnibus final rule. We encourage you to learn more about the changes that are contained in the omnibus final rule. OCR has been making a number of public appearances and outreach activities, and you are welcome also to look at the information we're developing on our website. And the compliance date is September 23, 2013. So, while we understand many organizations are appropriately beginning now to try to understand the omnibus final rule and implement the changes in their organization, we still think that you have time to learn more about it and to become acclimated and comfortable with it. So yesterday in a presentation that Jim Koenig, Ted LeSueur, and I did about cloud computing, we spoke, I think at some length, about business associate requirements and how the changes impact in the cloud computing environment. But also you could draw from that some broader understandings of how it applies for those organizations and their compliance with the security rule. So perhaps we will not emphasize that area as much as we normally would, and also we want to be cognizant of the time that we have today and make sure that we cover the other areas. So so briefly, the business associate changes in the omnibus final rule make significant changes. I mean, they are purposeful and they are intended to expand the responsibility for safeguarding both the electronic PHI in an electronic sense or in the information security spectrum, but also to apply privacy, the protections that are otherwise found in the privacy rule on business associates. So we clearly say that BAs must comply with the technical, administrative, and physical safeguard requirements under the security rule, and they're directly liable for violations. But we also say that the final rule specifies the privacy rule obligations of a business associate that may not have been directly detailed in the High-Tech Act, such as limiting uses and disclosures to what is permitted under the privacy rule, subject to what is allowed under the business associate agreement. This specifically includes compliance with the minimum necessary standards, providing breach notification to a covered entity, providing a copy of electronic PHI to either the covered entity, the individual's personal representative, as specified in the business associate agreement, and for disclosing PHI to the secretary in an investigation of the business associate's compliance with the HIPAA rules. In other words, if OCR seeks PHI from the business associate, just like a covered entity would have to supply that information to the secretary, the business associate must also now have this open and transparent relationship with the secretary. And also, for providing, the business associate is responsible for providing an accounting of disclosures if it is so requested. Here it is. So we discussed conduits to some extent yesterday. Want to add that the definition of business associates expanded so that it clearly includes patient safety organizations, PSOs that operate under the Patient Safety, Quality Improvement, and Accountability Act, and the health information organizations, which go by any number of acronyms, health information exchanges, e-prescribing organizations, and similar organizations. And the final rule also goes into a discussion of conduits. So since the inception of HIPAA, service providers such as post office and telephone companies have been exempt from the business associate requirements, as their access to the protected health information has been incidental as opposed to being on a routine basis. However, as technology has evolved, the application of the test of whether or not an organization was a conduit was becoming muddy. And so we attempted in the final rule to provide a brighter line, a clearer example of how to determine if an entity that is receiving information is a business associate or not. So it's important to remember that a business associate receives protected health information from a covered entity to provide some service or activity on behalf of the covered entity. So as a conduit, whether you're receiving paper or electronic PHI, only transmission services, including any temporary storage of PHI incidental to the transmission service, would make you a conduit. By contrast, a service provider that provides storage is a business associate, even if the agreement with the covered entity does not contemplate any access or access only on a random or incidental basis. The test is a persistence of custody, not the degree or whether or not there is access. So this also, the business associate provisions were also expanded to apply to downstream contractors, to the business associates of business associates. Downstream entities that work at the direction or on behalf of a business associate and handle protected health information are required to comply with the applicable privacy and security rule provisions, just like the primary business associate, and are subject to the same liability for failure to do so. This specifically does not require a covered entity to have a contract, a business associate contract, or any other contract with the subcontractor. Rather, that obligation remains on each business associate. In other words, they are the business associate of the business associate. Our goal here is to safeguard health information from end to end, from when it is created, transmitted, or created on behalf of a covered entity, and it moves on down a chain of custody, a chain of use, a chain in which there is access to EPHI. So a subcontractor is an entity to which a business associate delegates a function, activity, or service involving the covered entity's PHI, other than in the capacity of a member of the workforce of the business associate. So I'd like to move to the transition provisions for the application of the new provisions of the business associate rule. OCR recognized that there will be that time is necessary to renegotiate existing business associate agreements, and the final rule grandfathers certain business associate agreements up to 1 year beyond the compliance date. So if you have an existing business associate agreement that was in existence prior to the publication of the final rule, and that business associate agreement complies with the provisions of the existing provisions of the privacy and security rule, then they do not have to be renegotiated or put the new business associate agreement finalized until September 23, 2014, so long as they're not renewed or modified during that grandfather period. So only those agreements that are created after January 25th, 2013, modified after January 25th, 2013, or renewed during that period will need to meet the new business associate requirements, the standard language requirements for a business associate agreement on September 23rd, 2013. We have posted a revised or updated business associate template agreement on our website at hhs.gov/OCR/privacy. That contains boilerplate language that can be incorporated into a business associate agreement. Another question that I've heard quite frequently over the past few days is when negotiating with an organization, oftentimes they'll tell us we will not have a business associate agreement. But here's our agreement, our terms of use agreement, our service level agreement. And when you look at that agreement, it contains all of the provisions that would otherwise be required in a business associate agreement. And the question is, does that comply? And the answer is yes. The agreement that between the parties does not have to have a separate spelled out agreement that titles says business associate agreement on top. What is important and what is necessary to comply with the rule is an agreement that contains the provisions that have the minimum requirements as specified in the business associate rule. It does not matter the order in which they appear. It does not matter where it appears in the agreement, so long as it appears in the agreement and it's signed by both parties, and it serves to operate to safeguard the PHI and EPHI, and contains the terms as set out in the business associate standards in the privacy and security rule. So with that, we are open to questions, and with the proviso that I think we pretty much covered the issue of data being held by encrypted going into a from a covered entity to a business associate. I think we covered that pretty well yesterday. I hope there are a lot of questions about breach.
Thanks, David.
I have one question about business conduits. We have a lot of clients that are constantly struggling with email as a mechanism for passing information back and forth between themselves internally, and often they're using third-party email systems such as Google, such as Microsoft, such as Yahoo. And the question always arises, are these guys conduits or are they business associates?
So I think the appropriate measure is to do an analysis of what happens do those messages contain EPHI, is the first question. And then the second question is, where does the data go? I mean, certainly if you're an organization that has a service level agreement with one of these organizations and the data stays completely within the four walls of your information system, I know it's kind of an illogical analysis of that, but and that the other organization does not store or have access to a copy of it. I mean, I think that's the analysis. And I think, if the analysis finds that the organization does keep a copy or have access to a copy of the data, it's likely they would be a business associate. But each organization has to do that analysis. Yes, ma'am.
Do you view anything having changed when a covered entity has two business associates and they direct the business associates to work with each other? Do the business associates now need to have a contractual arrangement?
So if I understand what your question is that an organization has two business associates, and the organization has each business associate performing different operations on its behalf.
Right, but having to coordinate.
And the business associates do not trade information between themselves.
No, they would have to trade information between each other. So, for example, one might be maintaining a network, and the other might be using the network and having to interact with the person providing the other business associate providing the network.
Boy, that's tough. I'm having a difficult time visualizing that. But the general rule is that if one organization is performing a service or thing to enable the other organization in order to be able to carry out its obligations on behalf of the covered entity, then it would be a business associate.
Yeah, the two entities are providing different services to the covered entity, but having to work with each other.
Well, in this case, clearly the covered entity has a business associate agreement with
Correct.
each, and perhaps as a part of it directs one business associate to share information with another business associate. It's difficult to make those decisions sitting up here in the bright lights, with everyone watching me. I usually doodle, flip a coin.
Can I do that?
But I'll be thinking about that.
Okay. All right, thank you.
I have a question. It's kind of general, but the idea of business associates, have you found that that's had a chilling effect in regard to potential vendors and that sort of thing? Because I've already had people turn me away and basically say, well, we're not going to deal with this, particularly in regard to security. When you're talking about people like pen testers and those sort of contracts, they don't want to have to deal with the BAA and basically getting on board with that whole thing.
So from my point of view, I think Congress identified a problem, that there was this hole that sensitive information was falling into, and that there was no reliable measure to understand if the confidentiality of that data was being maintained. And if there was a breach of confidentiality of that data, and we see that based on our own analysis of breaches that are reported to HHS, then there needs to be some accountability, and this is how we got the accountability. So I think you can walk away from that and going, well, gee, maybe they really weren't going to be a great partner for me.
Yeah, and just to add to that, if you look at OCR's website with the breach notification numbers right now, the breach reports that we've received, just over, I think about 120 of them have involved a BA, the 500-plus breach reports. But the number of individuals affected by breaches that involve BAs are the largest. So approximately 21 million individuals have been affected by breaches thus far, the 500-plus reports. And more than, I think, 57% of those individuals were affected by breaches that occurred at the BA. So a lot of the information is stored at the business associate, and as such, they should be held accountable for that information.
So, David, I'm sorry to keep going back to this particular topic, and I do have a question for Kathleen. But first, as it relates to the entity that would be storing or holding PHI, if the data is encrypted, okay, and the encryption keys are maintained by the originating entity, is there any latitude or consideration if that warrants a BA with the entity that's storing the data?
So, as I said yesterday, this is an issue that, under the current preamble language, one can draw a conclusion that the issue is the persistence of data and that the organization has custody and the ability to access it. OCR is studying the question of whether the fact that the data is encrypted when it is transmitted to the data storage holder and the data storage service provider, I'm sorry, I said holder, service provider does not have the key, nor are they holding the key. So I think that presents an interesting issue that really was not brought to the attention of HHS during the comment period, and as is often the case during a long lead-in time between the effective date of the HIPAA rules and the compliance date, OCR has the luxury of looking at specific issues that are brought forward that were not identified during the comment process. And this is one of them.
Okay. So, Kathleen, the question for you is, I know you made it clear there's 4 key points that need to be individually assessed to determine if it's a breach. So, very pointed question, though. And you made a point during that commentary. If a laptop's stolen and it's encrypted, if a mobile device is stolen and it was successfully remotely wiped, does that still constitute or warrant the need to notify?
So it would just depend on the exact situation. So questions you would ask yourself within the risk assessment would be, how long was the phone gone? How long was it unattended? If you're talking about a situation where something's encrypted, was it encrypted in accordance with the NIST standards, or was it simply encrypted by another means? And not to say that might not preclude you from notifying, but it wouldn't qualify for the safe harbor. Yep. So if you wipe a phone within minutes of the phone going missing or being lost or stolen, that's different than we found out 3 months after the fact that the phone was gone and then we wiped it. So those are all things that you would want to walk through within the context of those 4 factors of the risk assessment.
So, Katie, would you say that under the new analysis of whether or not there's a low risk of compromise, that organizations still have the opportunity to do a case-by-case analysis and apply the specific facts of the situation to the standards that have been enunciated in the final breach notification rule?
Yes, I would say that. Yeah, I would say that the risk assessment has always been important. I think it's just emphasized more so by including these 4 factors in the reg text. So, like I said before, I think a lot of covered entities and business associates might already be using these factors, and if so, I think the transition to the new standard will be quite easy. But if not, we're hoping that these 4 factors will provide covered entities and business associates with a more objective test so that there can be more uniformity across industry. Yes?
A couple questions. One, with respect to a data breach, if you have, say, a breach involving 500 individuals and only half of that information arguably is sensitive, right? So say you had information about say, drug use, for example, and half of those individuals it related to taking aspirin, but half of it related to maybe an HIV drug or something sensitive. Mm-hmm. Is it appropriate then to make a determination based at an individual level based on each individual's, the sensitivity of information with respect to each individual?
Sure. So you're no longer looking at the subjective test, the risk of harm to the individual, but those are factors that you would want to take into consideration, particularly under the nature and extent, to determine whether or not you're reporting a 500 plus breach or you're reporting a less than 500 breach. And so you would want to look to the types of information. So perhaps you lost one laptop that contained highly sensitive information for 250 patients, and you lost something with less sensitive information. That's something that if you've ever reported a breach to us, you can parse out on the notification in the description of the breach. But that's something that, as an individual organization, you would really want to look through in the risk assessment when you're determining what type of breach to notify the Secretary of.
Okay. I also had a second question about the definition of business associate and specifically the language around transmits or maintains. Is it appropriate to infer from the conduit discussion that transmits, as used in the definition, infers the conduit discussion essentially, so that if you're purely transmitting data but you don't have custody, then you would not be a business associate? Or I guess I'm sort of struggling about why the word transmits was included as sort of a standalone in the definition given the discussion around conduits.
Sure. So an entity in providing a service to a covered entity or to another business associate can transmit the data, but as a part of providing that service can either have routine access to it or use it for, or attempt to use it for another purpose, maintain a copy of it, or not. And that is the distinction that is involved in the conduit discussion.
Okay. So if you transmitted but you did not maintain custody, then you would not be viewed as a business associate?
Sure. So I think a good example of a pure conduit is if you sent a packet of data across an information network maintained by the third party, and it's like a bolt of lightning. It originates from the sender, and it is received by the recipient, and there is no copy, no persistence, and no access by the transmission agent. It just flows through it. Then they would be a conduit. Yes, ma'am.
This question is for Kathleen. Thank you for explaining the new breach analysis. Could you help me understand the difference between compromised and harm? Because when I go through the factors, and maybe I just keep defaulting to harm because that's what we're all used to, but for example, when you think about the nature of the information disclosed, whether or not the recipient was able to retain it, in my mind, that all looks like harm. Mm-hmm. So I need help understanding what is compromised.
Sure. So I think compromised is basically just an analysis of those four factors. But I think the way that the rule has moved away from harm is that you no longer need to look at in a sense, you will still think of the individual, but that is not the standard any longer. You're looking at how the information and if the information was actually compromised. And I think these four factors are helpful for providing an objective test, but I think what will really help is we have worked on some risk assessment guidance that really fleshes out how to determine when information has been compromised and provides examples of what OCR thinks would perhaps fall into the low probability of compromise versus the high probability of compromise. So I think things like that will help entities determine what is low versus high. But I do think you can think of examples, and even in reading the rule, the preamble does provide examples of situations that OCR would say would qualify as a low probability of compromise. So if a fax goes to the wrong provider, and the provider calls the covered entity and says, "I've shredded this piece of paper," that's likely a fairly low probability of compromise. And you would no longer be looking to whether or not you think that individual would consider themselves harmed, but was the information compromised?
I'm sorry, but the gentleman behind you was waiting for a question, and it will have to be the last question. I'm so sorry.
Okay. Well, thank you very much. I appreciate it.
Thank you.
My question has to do with electronic EPHI breaches and sort of the inherent inability to quantify those as required by the risk assessment standard unless it's an immediately recognized and recallable breach, like you sent an email to the wrong doctor. The reason I ask this is because once EPHI is breached, it's impossible to know with any certainty who has possession of it or who will have possession of it. It's also impossible to know with any certainty how much data was breached in very many cases, because you can identify that some information was breached at some time. Typically, these things are discovered weeks or months after the breach, and it's like you can identify when a can of peas has been taken out of the pantry because the can of peas is missing. But data doesn't work that way. It gets copied and redistributed, so you can't quantify who has it or how much has been breached. So, how do you work the standard with that being the reality of how electronic breaches work?
Well, I think I'll let David jump in a minute, but I think in your risk analysis, it is important to know what information you have. To keep track of what laptops contain what information and what dates and for individuals. And with regard to breach notification, if you're not sure about the number of individuals affected, so if you know it was from 1995 to 2000, the patient records from that time span, you are required to cast a wide net. So if you don't know, you do have to notify individuals that you think might have been affected or the PHI might have been compromised by that breach.
And that is exactly why the circumstances that you lay out are exactly why we understood covered entities and business associates be having such a difficult time with that risk of harm analysis, because you're right. Once the peas are out of the can, what happens to the pea that ran underneath the refrigerator? How do you count that? Well, the pea that ran under the refrigerator has been compromised, and so you can in the electronic sense, it actually makes it much easier to evaluate what was the low risk of compromise. And since you have an idea of the scope of the data, or you should know how much data is being held in a certain tranche and who has had access to that data, or if you don't, that leads to other problems. But for purposes of the breach, it should actually make the analysis easier.
Okay.
Thank you very much.
Okay.
Thank you.
Water glasses, clean water.